I'm going to be talking to you about the state aid tax cases, but we've had a slightly interesting development in the state aid tax space in the last week or so that's going to change things a little bit. So in terms of the state aid tax cases, this is how I like to think of them. We have the good. That's Apple. I think the Commission should win. I'm not convinced the Commission will win, but right now I'm convinced the Commission should win if they got their arguments right. That's probably the case I know the most about because I'm Irish. We have the bad. The bad is Starbucks. The Commission should not win this case for so many different reasons. They may yet turn out to win it, but this is not their case. And finally, we have the ugly. Anyone want to guess who's the ugly? It's Luxembourg. Any Luxembourgers in the audience?
She left yesterday.
Luckily. Okay. So in terms of Luxembourg, at the moment, we have a state aid challenge into Amazon, we have one into Fiat, and we have one into McDonald's. And they all relate to slightly different parts of the Luxembourg tax system and tax ruling system. So, you know, this is one where I'm not convinced that state aid is the right tool for the job, but yet you can see why the Commission desperately wants to react. So if we just go through the cases in brief, I might just draw them up here so that it doesn't leave any record. That's why I didn't put my commentary on them on the slides. Okay, so we'll start off with Apple.
I was waiting for somebody to say that.
Okay, so in this diagram, we have the various Apple sales international companies. They maintain that they live nowhere for tax purposes, and under Irish law, this position was somewhat okay. All of the activities of these companies take place in Cork in Ireland, where they employ about 4,000, 5,000 people. So the branch is in Ireland. You have a big pot of money, which is the pot of money belonging to the company, and you have a letter from the tax advisor to the Irish tax authorities saying, this pot of money is too big due to transfer pricing, and we propose giving you this small pot of money. But there's no attempt to explain why under Irish tax law, the small pot of money should be taxable instead of the big pot of money. And there are some quite thinly veiled threats about jobs. So in terms of, does this case feel like a state aid case? Yes, it does. No other taxpayer in Ireland has the same structure. No other taxpayer in Ireland would have a comparable ruling. There may be other rulings, but one would hope none as blatant as this one. There is no attempt to apply Irish tax law in the content of the ruling. It looks like the advisors simply made up a number and put it in a brown paper envelope, which we do love in Ireland, and handed it over. So that's why I think the Commission should win this case. Why do I think there are doubts as to whether the Commission will win this case? The Commission is arguing that the problem was Ireland didn't apply OECD transfer pricing rules. Ireland didn't apply OECD transfer pricing rules to anyone. And in order for a tax measure to be a state aid, it must be selective. It can't be selective to not apply the same rules to everybody. What is selective here is that they didn't apply Irish tax rules to an Irish taxpayer. So this is the one I think the Commission should win. Let's move on to Starbucks.
Philip Baker would say they will not win this case because he's acting for the
And the other
government.
point that must be made is the Apple case, we don't know yet because the Commission hasn't launched it, hasn't given us its reasoned opinion, but the upper scale of the Apple case could be 25, 30 billion. This is the big case. Okay.
I'm waiting for the comment.
Okay, so next up we have a simplified version of the Starbucks structure. So there are numerous US entities involved. The entities have set up not one, but I've simplified it slightly, a couple of Dutch partnerships, CVs, which are themselves partners in a UK limited partnership. So those two triangle entities are transparent for Dutch purposes, for UK tax purposes, but oddly not for US purposes because the US reverse checks them. And so this means that when a royalty leaves the Dutch company at the bottom, the Dutch company at the bottom sees the royalties going to the US companies at the top, so the Netherlands doesn't tax it. The US companies see that royalty going to the partnerships in the middle. It says they're foreign companies, so it doesn't tax them, so the royalty receipt ends up not being taxed. Why do I say the Commission should lose this case? Well, first of all, everybody here is a professional, and professionals make judgment calls all of the time. I mean, you know, if you're a chemist, you know if you add one chemical to another, a certain reaction will occur. As a professional, you don't know for certain what will happen. You make your best estimate, you make your best judgment call, you look at the facts, you look at the alternatives, and you make a determination. The Dutch tax authority looked at the various information, the various transfer pricing methodologies in Starbucks, and agreed with the taxpayer that a particular transfer pricing methodology was appropriate. There's one small element where it appears the Dutch tax authority may have made a mistake, but it does not look like an intentional mistake. It's not like the Irish tax authorities where the taxpayer said, pick any number. The Dutch tax authorities were actually given a professional letter explaining everything. And so on that reading, the Commission seems to be thinking that it has the power to review every advanced pricing agreement within the EU and to substitute its view for the local tax authority's view. Now, in most member states, same as in Ireland, a court doesn't get to substitute its view, and the same is true in one of the state aid cases we're looking at later. The court doesn't substitute its view for the view of the determining authority unless the original view was completely unreasonable. So, you know, if the Irish tax authorities decided tomorrow to levy a tax charge on the basis that somebody's hair was red, of course the court can substitute their view. That's absurd. If the tax inspector decides to make a determination and it is within the realms of the facts before them, the courts will not necessarily impose their view over those original views. And so that's something that we're seeing coming up, and that's something that's quite relevant in the Starbucks case. And now on to the ugly. So let's quickly draw a couple of Luxembourg structures. Okay, so the first structure that's up there is the Fiat structure. It's reasonably commonplace for financing companies. You have a Luxembourg company which is funded by its parent with equity, so with capital. That Luxembourg company lends the cash that it has out to other group companies as debt, which bear interest. And then at that point, the Luxembourg tax advisor used to go to a gentleman by the name of Marius Cole. You would go to Herr Cole and you would say to him, oh, but if the Luxembourg company is equity funded, then it has too much profits compared to banks because no banks are equity funded to this extent. So let's pretend some of this equity is in fact debt. And if some of this equity was in fact debt, then it would have to carry interest at this rate, and therefore this is the taxable profits which would be left behind. Now, Luxembourg was pretty unique in the world of the EU in granting transfer pricing adjustments which eroded its tax base as distinct from which increased its tax base. But however, this is the structure that Ms. Vestager does not like in relation to Fiat, and she has suggested that Fiat owes Luxembourg about 30 million in corporation tax. Now, interesting as the Fiat structure on its own is, what is far more interesting is the McDonald's structure, which is the next structure down. And if Ms. Vestager makes the next case, she could give the world of multinational corporations a complete heart attack. She could, in fact, cause another global financial crisis because this structure is so common. So the concept of the non-trading branch structure is that you have a Luxembourg company which obviously does not wish to pay tax at 29% in Luxembourg. So what the Luxembourg company does is it sets up a branch in a friendly tax jurisdiction. The obvious ones for that are Switzerland, Ireland, Cyprus, and Hong Kong. In those jurisdictions, you tell the local tax authorities that there is no permanent establishment under the tax treaty, and therefore there is nothing for them to tax. There is no permanent establishment as a matter of our domestic laws. Luxembourg determines that there is a permanent establishment, and that permanent establishment results in Luxembourg exempting the profits of the permanent establishment from the Luxembourg tax net. And this structure, as you may guess from my familiarity with it, I may have done once or twice over the years. It was the subject of a number of LuxLeaks revelations in relation to the PwC structures. And what I found particularly interesting was that a number of those PwC structures told the Luxembourg tax authorities things that would have stopped the structure from working in Ireland. This structure required walking a very precise line between what was acceptable in the state where the branch was located and what was acceptable in Luxembourg. And if you walked, so Luxembourg ideally wanted an office in Ireland with 20 employees. If they did that, the profits were taxable in Ireland. Where we normally ended up was that it rented an office space from a small accountancy firm who would put its plaque on the door. Mr. Cole liked plaques on the door for some reason. It would hire a part-time bookkeeper who would very often be a retired partner from a Big Four firm who would be paid something in the region of 30,000, 40,000 a year to do almost nothing, to produce a small set of books. And on that basis, Mr. Cole would rule that the profits were not taxable in Luxembourg. I have to say, I always wondered quite how he got so comfortable with that, but he did. And that structure is remarkably commonplace and certainly was in almost every UK FTSE 100 group 5-6 years ago. It was sometimes used for IP, it was often used for financing. So we'll wait and see how that turns out.
It was the McDonald's, or that was the...
That's McDonald's. McDonald's is a non-trading IP branch in Switzerland. Fiat is an equity-funded Luxco, and Amazon is a variation on the Fiat theme. So these are our current high-profile state aid cases. Starbucks, as I mentioned, is about the correct transfer pricing methodology, but to my mind, Starbucks is a judgment call, and I do actually object to the Commission thinking that in an area where they don't have competence, being direct taxation, given the concept of subsidiarity, that decisions should be made at the lowest possible level, that they should be able to substitute their view for a reasonable view being taken by a tax authority, as distinct from our next kid on the block being Apple, where there doesn't appear to be any reasonableness in the view being taken by the Irish Tax Authority. Now, in Starbucks and Fiat, the Commission has already determined that the state aid to be clawed back is in the region of €30 million. In the context of these structures, €30 million is a pittance. It's absolutely nothing. You would almost wonder whether the taxpayers would bother fighting for more than the principal, given how valuable these structures are to them. As I said, we don't yet have a number for Apple, but what we do have with Apple is some very interesting data coming out of Ireland. In Ireland, taxpayers, corporate taxpayers, pay their tax in installments, and the vast majority of large corporate taxpayers have December year ends. So they tend to pay in the same months relating to a December year end. However, in the months that would apply to a large corporate with a September year end, of which there is only one known in Ireland of a very large corporate, our corporation tax receipts are increasing by between 1 and 200 million euro.
By how many?
Between 1 and 200 million. And Apple is the only major taxpayer who pays tax in March. So unless somebody else is trying to mess with the data, Apple has seriously revised their filing position. Not slightly, not to the tune of 2-3 million a year. I mean, if you think about it, 150 million extra in corporation tax equates to an extra, at 12.5%, equates to an extra north of €1 billion a year in profits, closer to €2 billion a year.
You will have a surplus this year.
We're running a little surplus already, and it's our corporation tax receipts going crazy, and they're going especially crazy in March and September. So, yeah, Apple seems to be helping us out, making sure that we're not going to run out of money before we pay our legal fees. They're doing their bit. So we have Fiat with its imputed interest, McDonald's with its non-trading branch, and then there are numerous Belgian regimes that are also being investigated at the moment, which are receiving less profile. Now, interestingly, Fiat and McDonald's both appear to have paid the tax in Luxembourg. Has there been anything on whether Starbucks have paid in the Netherlands, or they're just competing?
They appeal.
They're appealing, so they haven't paid.
Starbucks as well as the Dutch government.
Yeah, and it appears that when we get the Apple determination in Ireland, it will be Apple and the Irish government to appeal as distinct from one or other. But the Belgium case at the moment is actually the biggest case. It's about 900 million in aid across many, many different taxpayers, which the Commission wants clawed back. And I know for years that Tom told me Ireland should be cleverer and have a tax regime like Belgium's, where nobody realised they were a tax haven. They just quietly got on with it under the radar, but that radar has now appears to have caught them.
I think about half a year or a year ago, I was at a tax conference, and there was this man from the Commission about the rulings, and he was arguing that they were working on something about 200 cases, various cases in various member states.
Yeah, and yes.
Pending.
And yet, does anyone know how many staff the DG Comp have to be working on 200 complex tax cases?
Few people. I think there are like 10 people.
Yeah,
This team is like 5 to 10 people.
Yeah.
A handful.
Exactly, and like for one of these complex cases in a domestic tax authority, you could easily have 5 or 10 people working on one of the cases. So if they think they're going to work on 200 cases, and gee, this is another point that's being missed in this rush to share information, to share data, is that without staff, there is so much a tax authority can do and no more. Without appropriate staff, there is so much the Commission can do and no more. We have, under the current tax exchange directive, there is an obligation on member states' tax authorities to automatically share data in relation to certain kinds of income. I have personal experience of that not being invoked, where one of the tax authorities was the UK, who would be considered to be one of the best staffed and one of the more savvy tax authorities within the EU. And if the UK tax authorities can't deal with the automatic information exchange in the existing Mutual Assistance Directive, where it wasn't a case that their tax was being avoided, their tax was being evaded, I'm struggling to see how throwing all of this extra data at tax authorities is actually going to help if you don't give the tax authorities the staff to deal with it. Okay, so our less high-profile tax state aid cases, which are actually massively interesting at the moment, there's two Spanish cases. One is the Santander case, and the other one, which is kind of hot off the press, is the Netherlands Maritime Technology Association case. So if we look at the provision that deals with state aid, Article 107 says that you cannot have any aid which is granted through state resources. Now, a tax break is always granted through state resources, in any form whatsoever which either distorts or threatens to distort competition. And again, that test is not overly contentious. But the next point is the point that is being missed, I think, by the Commission in a number of its cases at the moment. So it must distort or threaten to distort competition by favouring certain undertakings. Favouring certain undertakings, it must be selective. It cannot just form part of the general scheme of a tax system, it must favour certain undertakings. And if you look particularly in relation to Fiat, in relation to Starbucks, and the press releases made by the Commission seems to be arguing that because small companies tend not to engage in cross-border activities, therefore tend not to have transfer pricing disputes and lack the capacity to set up a global central entrepreneur structure or a global financing structure, that concepts like the Luxembourg tax rulings are distorting competition between SMEs and large corporates. And you can see a certain sympathy for the argument, but it's also completely false. Any company with an undertaking in Luxembourg could go to her coal and seek a ruling. It didn't matter what sector you were in, it didn't matter what you were doing. All that mattered was that you went to her coal and sought a ruling. And so saying that a little French company with no activities outside France or a little French coffee shop can't compete with Starbucks because it can't source its beans globally via a Swiss entity is not the point. It doesn't have any activities in the Netherlands in order to be competing with Starbucks in that market. There's nothing to suggest that if a little French coffee shop could set up a roasting operation in the Netherlands, that the Dutch tax authorities wouldn't grant them an APA. This is why I think the Apple case is very unique in that there is no attempt to apply Irish tax law. But once you start looking at tax law being applied fairly, being applied consistently, being applied with, yes, judgment calls being made by tax authorities, it's very difficult to see how you can prove that that tax law is somehow selective. So, as I said, in terms of Apple, you have a ruling which bears no resemblance to Irish tax law. You have no comparable structures. You have no comparable rulings, and it does appear prima facie to be selective. Yeah.
Well, I have one remark. I tend to agree and not agree with you. We had, for many years ago, we had a special financing regime in the Netherlands for financing companies. And that was drafted as a general tax measure. So not
we had similar in Ireland.
So not specifically aimed at certain companies. But in the end, the Commission argued, if you calculate all the various requirements together, the end result is that only a specific number of companies are able to meet these requirements, and therefore it's a specific measure specifically aimed at certain companies, and therefore it is to be regarded as state aid. So, yeah, I agree when you say, well, if the measure is available to everyone, it's not selective, but
Well, I'm going to agree with you and disagree with you on that, in the sense that Ireland also had a financing company regime. So we had a 10% tax rate for financing companies based in the IFSC. And the Commission took state aid proceedings against us on the basis that by giving this preferential tax rate to financing companies only, it was selective. And we didn't actually wait for it to go to the Court of Justice. Ireland agreed to change its rules. But as part of changing its rules, Ireland introduced the 12.5% corporation tax rate applicable to all active profits in Ireland. And the Commission had a look at that at the time and determined that that was not selective because any business in the world can put activities in Ireland which could avail of that rate. However, I think we need to get on to both Santander and the Dutch Maritime, I've forgotten the name of the case, Netherlands Maritime Technology Association. So Luxembourg, the reason I called it the ugly, you can see from the point of view of the NGOs, you can see from the point of view of tax justice campaigners, the Luxembourg tax rulings are potentially amongst the most toxic in the EU. If you look, for example, at the changes to the Parent Subsidiary Directive, obliging states to tax hybrid mismatches, Hercole used to maintain that the Parent Subsidiary Directive itself prevented him from taxing the interest on hybrid instruments. So he used to, in a sense, implicate EU law in some of his rulings. But the core problem, again, is the Luxembourg rulings must favour certain undertakings over other undertakings which are also active in Luxembourg. You can't compare a company with no activities in Luxembourg to a company with activities in Luxembourg to say Luxembourg is giving a tax advantage to the one entity that Luxembourg can tax. If you follow this logic through to its conclusion, you need direct tax harmonisation within the EU, or certainly in the corporate income tax sphere. Because if you don't have direct tax harmonisation, there will always be differences within the tax systems. And those differences don't necessarily invoke competition law. Yes, sometimes they do. I can see how they do, but they don't always. And it appears that the Commission may be a little bit enthusiastic about this. So this case is the Santander case. Do we have any Spanish people here?
They were here yesterday. Oh, they're down the back.
So can you correct me if I say anything incorrect about the Spanish regime? But as I understand it, Spain used to allow amortization where a Spanish company purchased a foreign company, they could amortize the goodwill acquired for tax purposes in Spain. Does that sound right? Okay, I'll keep going and assume it is. So what we saw in, especially around 2006, 2007, was Spanish companies gobbling up a lot of their European rivals. There were a lot of big acquisitions in the UK, for example, where Santander bought Abbey National, Ferrovial bought BAA. There were numerous cases like that. And there was this suspicion that the Spanish acquiring companies were able to bid higher because they were going to get this tax base erosion back in Spain through being allowed to amortize the IP. So eventually somebody made a complaint to the Commission and the Commission took action against Spain, alleging that this regime was a state aid. Now, at this point in time, Santander is in the General Court. So the Commission alleged it was a state aid. The taxpayer maintained it wasn't. The taxpayer appealed against or challenged the Commission's decision before the General Court. And that decision was handed down in November 2014, so it should be in the Court of Justice pretty soon now. So it really is one to watch. So the General Court stated that it's clear from the case law cited above that the definition of category of undertakings which are exclusively favoured by the measure at issue is, that should say, prerequisite for recognising the existence of a state aid. So you must be able to determine which undertakings are benefiting in order to determine there's a state aid. And the Competition Commission in relation to Luxembourg seems to be saying that that category of undertakings is anybody big. If you're big, you can benefit, therefore you are benefiting. If you're small, you can't benefit. It doesn't seem to be a sufficiently defined category of undertaking to my mind. The court went on to say that where the measure at issue, even though it constitutes a derogation from the common or normal tax regime, where it's potentially available to all undertakings, it's not possible to compare, in the light of the objective pursued by the normal regime, the legal or factual situation of undertakings which are able to benefit from the measure from that of undertakings which cannot benefit from it. So again, this comes back to the point that if you have an undertaking which doesn't operate in Luxembourg because it's too small to benefit from operating in Luxembourg, you don't have an undertaking to compare to Amazon, to McDonald's, to Fiat. If you could point to a small Dutch company with a different APA to Starbucks and could somehow maintain that there was a reason for this, then perhaps you could argue that the rules were being applied selectively. In the Irish case, you can point to any number of examples where we generally have to convince the tax authorities that the tax law allows us to do something as distinct from just writing to them and saying, you may tax this number if you feel like it. So Santander is one to watch, and I think at the time when Santander was determined by the General Court, a lot of advisors were expecting that the Court of Justice might overrule the General Court, that the General Court got this wrong. But as a result of the more recent decision in Netherlands Maritime Technology Association, that's not actually clear that that's likely to happen. So effectively what the General Court was saying in Santander is that because a bank that acquires a UK bank can get this amortization, a Spanish construction company that acquires a French construction company can get this amortization, that the amortization regime is available to everyone. It's not specific to certain types of undertaking. The Commission's argument was that because you didn't get this amortization if you acquired a Spanish company, and more likely domestic mergers will be smaller than cross-border mergers, the Commission felt that this was evidence of the selectivity. So this case is of fundamental interest for the Luxembourg cases. But the General Court felt that there was insufficient selectivity about the regime because it wasn't restricted by sector, it wasn't restricted by anything else besides the fact that you had to be big enough to fund a cross-border acquisition. But here's the very recent case. So in this case, a bunch of shipping interests from the Netherlands made a complaint to the Commission about potential state aid breach by the Spanish tax rules. And I haven't gone to the whiteboard in a while, so I'm going to draw a picture. Okay, so to briefly explain the Spanish rules at issue. So the boat here represents a ship owner. So the ship owner wants to buy a new ship. They want to purchase that ship from the shipyard for a certain price. Under the Spanish tax regime, if you structured the transaction so that a lessor, which was funded indirectly by various high net worth individuals in an economic interest group, they funded the lessor who paid for the shipyard, and then the ship owner leased the ship for 3 years, at the end of which he purchased the ship. But before he purchased the ship elected itself into a different tax regime so that The individuals in the EIG got the tax depreciation for the first 3 to 4 years. Under normal circumstances, if that asset was sold within 3 to 4 years, the tax depreciation would have been clawed back. But by the ship being elected into tonnage tax before that happened, the clawback didn't occur. So the net effect of this was that there was effectively a 30% subsidy on ships being acquired by Spanish shipyards if this structure involving Spanish high net worths were used. So the various Dutch maritime groups complained about this and said that it was a state aid. The Commission looked at it. One of the first reasons why the Commission felt that it wasn't a state aid was that it held the tax break occurred at the level of the European interest grouping, the individuals, not at the level, so the investors rather than the businesses involved in the structure. Yet, as part of its finding, the Commission also found that that tax break was shared between the lessor and the European interest grouping. Now, any tax professional can tell you, we can price tax into anything you like. If there is a tax cost to a contract or if there is a tax benefit to a contract, it will not happily by accident sit in the hands of one party. We will share it. We will figure out how to do that. So commercially speaking, it doesn't matter where in a structure the tax benefit falls, it will get priced throughout the structure. So in this case, I think the Netherlands Maritime Technology Association was absolutely correct and the European Commission was absolutely incorrect. It appeared to have looked at what appeared to be somewhat irrelevant considerations, and it appears to have not given sufficient consideration to the relevant considerations. So the Commission concluded that this was fine and that it wasn't a state aid, and so a complaint was made to the General Court by the Dutch interest grouping. And the General Court upheld the findings of the Commission. It went to the Court of Justice on the 14th of April, so that's why I said it's hot off the press, it's very new. And the Court of Justice held that the General Court observed, however, that since the measure was in principle applicable to any undertaking of any size active in any sector of the economy, there was no need for the Commission's examination to concern the leasing companies or the undertakings that the appellants classed as intermediaries. And I think this goes back to your point about the financing companies. The Dutch point was, if you looked at this as a whole, there is only one kind of asset that is big enough and always bespoke that you would use this regime, and that asset, in order to avoid the clawback of the tax depreciation, had to be capable of getting itself into the tonnage tax regime, which is restricted to ships. This was a shipping measure looked at holistically. This was support for Spanish shipyards given indirectly, which is what the complaint was. And the Commission held it wasn't. The General Court and the Court of Justice both held that the Commission's position was not entirely unreasonable. I think the mistake made by the Commission in this case is more fundamental than the mistake they're alleging the Dutch tax authorities have made in Starbucks. And yet the General Court and the Court of Justice, as is normal for courts all over the world, have held that the Commission's decision was not so unreasonable that they could substitute their own findings over it. But that is exactly the opposite of the position which the Commission is taking in relation to some of the state aid challenges. And that being the case, one has to question whether perhaps the Commission is going to struggle to maintain legitimacy around these challenges, particularly because one assumes that the Dutch in particular will have been paying attention to this case, given it involves Dutch interests on the opposite side of a state aid complaint to the one at issue in Starbucks.
That goes exclusively to the marginal appreciation and the limits of review of such cases, really. Because if you all that really goes exclusively to the question of marginal appreciation of the Commission over state aid cases, and the scope of review. Because if you treat it as a normal case of qualification juridique, then of course it would go the other way. If you accept that the Commission has an option, has room for maneuver, then the situation is different. And even in classic antitrust cases, we already know from the Alrosa case, again, where the Commission has accepted commitments, and the General Court held that this was unreasonable, and even though we know that these are only subject to limited review, the European Court held that even that limited review was too much, and the Court should have deferred even more to the Commission's judgment. So here the question, maybe it's not whether it's right or wrong, it's whether it's reviewable or not.
It is whether it's reviewable or not, but it's this, the contested decision could apply to any undertaking of any size active in any sector of the economy. Yes, and that is what's the problem with Marius Cole's judgments, because a ruling from her Cole could apply to any undertaking of any size active in any sector of the Luxembourg economy. He didn't discriminate. A traditional advanced pricing ruling, an APA, can apply to any undertaking of any size in any sector of the economy. So the Commission, for the Commission to have defended this case so robustly when it is itself arguing exactly the opposite in a number of other cases is perhaps an interesting approach. It almost looks like the Commission is taking the, one would think, very legally questionable decision of, if we don't initiate cases, we can't be bothered, but if we initiate cases, the law goes out the window. I mean, that's probably a bit of an extreme way to put it, but this case must be this case is quite unsettling as a practitioner. I think the Commission got this case completely wrong, but at the same time, if they got this case right on the basis that it could apply to any undertaking of any size in any sector of the economy, they need to drop a number of their state aid challenges right now. It's difficult. I can't see how you can escape that conclusion. So yeah, our next steps, both the taxpayers and the member states can appeal to the General Court to challenge the finding of the Commission that there was a state aid. It seems likely that both will, or probably they will jointly, with a further appeal to the Court of Justice. I imagine that we will see decades of litigation over the correct procedure here. Now, in that context, it's interesting that the aid the Commission has alleged in relation to Starbucks and Fiat is 30 million, so maybe, I mean, they may litigate for years, but they may make a judgment call to drop the cases. That's why it's going to be particularly interesting to see what number the Commission eventually come up with on Apple. There was the suspicion that the Commission has delayed issuing its ruling on Apple to allow us to elect a government, but we got the better of them. We had an election and we have no possibility of having a government anytime soon. So that appears to be delaying the determination of the Commission, because it would obviously be massively uncomfortable for Irish politicians to be trying to form a government while at the same time trying to say, no, Apple, we don't want those billions. Honestly, no, keep your billions, put your hand back in your pocket, while we've just escaped an EU IMF program. I think there possibly is the possibility of involving the domestic courts here on selectivity, which I don't think is being considered. So, for example, let's say that the Commission is alleging that the Dutch tax authority agreed the wrong transfer pricing methodology with Starbucks. Let's say, hypothetically, the Dutch fisc tomorrow decide to raise the assessment based on the transfer pricing methodology the Commission says should apply. If the Dutch courts said, no, as a matter of Dutch law, that's the wrong methodology and you should use the methodology agreed with the Dutch fisc to begin with, that creates a problem, because if the Dutch tax authority if the Dutch courts are saying, Dutch domestic law is this, the Commission cannot then be arguing that the ruling, as distinct from the law itself, is a state aid. And this is where I see these cases being so problematic, because they involve judgment calls at the level of the taxpayer and their tax advisors. They involve judgment calls by the tax authorities whether to accept or reject those agreements. And ultimately, they may involve judgment calls by the courts when the courts are reviewing the evidence before them as to what the appropriate methodology might be. I mean, the UK introduced its transfer pricing rules in 1988, and it had its first transfer pricing case before its tax appeals tribunal in 2009. So it took 21 years in a country the size of the UK, one of the larger economies within the EU, to have its first judicial oversight of a transfer pricing study. And in that case, the tax authority won. I think there have been 2 cases since, but there wasn't any case law. And that's, I mean, does anyone here have experience of there being significant judicial precedent in relation to transfer pricing?
There is very few cases.
Yeah, but from a Netherlands perspective, you don't want to rule the case because you don't know anything about transfer pricing as a judge.
Yeah.
So what you do, you apply burden of proof rules. And that's how you are going to decide the case, not on the contents, but on the proof rules.
Yep. So yeah, just some more points. In relation to the aid clawback, the Commission will look for a clawback for 10 years of the aid, including interest. Now, again, coming from the UK in the last number of years, there has been a huge amount of litigation as to what is the correct amount of interest and what is the correct basis for awarding interest when it's the member state who benefited from a breach of the treaties. There hasn't been quite the same level of litigation in relation to interest on state aid, but it's clear that interest must be due. Fiat and McDonald's have paid the tax pending the appeal. We understand, I think, that Starbucks haven't. Apple, if the finding goes against them, almost certainly won't. So then by the time you come to clawing back the aid, the interest at stake potentially could exceed the amount of aid at stake. The Commission, for example, notified Ireland of a decision on alumina oil. So this is some kind of weird oil which is now used by, I think, Rusal, Russian aluminium, for the manufacture of aluminium within Ireland. There's only one taxpayer, so it was a much easier case to make on selectivity of the aid. As I said, the Commission notified Ireland in 2000, and the case is still being litigated 16 years later. That case, the amount of tax at stake is less than 10 million. Ireland will not give up on Apple anytime soon. And I fully expect the judiciary in Ireland will somehow get themselves dragged into the mess at some stage along the way. So does anyone have any questions?
I have a question. These cases, some of them are very much based on transfer pricing.
Mm-hmm.
Transfer pricing is always about 2 countries. The country that receives the profits and the country that loses the profits.
Yeah.
What made me think when hearing about these cases was, what about those countries which actually got screwed up? Because it was not the Luxembourg, it was not the Ireland who are actually losing tax revenue. These are other countries in the EU and elsewhere. So I wondered to what extent there was discussion about the primary adjustments taking place in the respective jurisdictions.
Well, this is what...
And rather than just clawing back what actually doesn't belong to respective jurisdiction, giving, of course, clawing back the residual, which may be there, but actually making corresponding adjustments to the extent that the primary jurisdictions claim what is rightfully theirs.
Well, this is where it gets very interesting. So if we take, for example, the Fiat case, and we say that in this case, the interest expense which Luxembourg imputed should have corresponded to interest income in Italy. It's up to the Italian tax authority to raise that assessment as they want. Now, at the moment, we have seen Italy and France raised significant assessments on Apple. I haven't seen significant assessments being raised on Fiat or Starbucks yet, or not, as the case may be. So if under domestic Italian law, Italy can make their assessment on Apple stick, and they can get a corresponding adjustment off Ireland under the double tax treaty, then good luck to them. But the problem is, at the moment, certainly in the Irish case, Ireland is fighting mutual agreement requests, corresponding adjustment requests on a very technical basis, the reason being that we can't afford them. There's too many. So if the Italian tax authority is within time and so forth, will Ireland make the corresponding adjustment? Yes. If the Italian tax authority tries to make an out-of-time corresponding adjustment, will Ireland hand over the tax? No. Because what Ireland absolutely can't afford is the possibility that we could end up paying out billions in corporation tax that we don't have and never getting the billions back from Apple.
Then you would really have to claw back.
Then we would really have to claw back, and we're maintaining that we don't have to claw back, so we're not going to do that. So yeah, we are definitely seeing the other countries making the corresponding adjustments. The primary adjustments, and then waiting to see whether the corresponding adjustments are being made. But at the moment, it's not looking like the tax system will want to do that. And this is the problem with using state aid law, which is designed for a different purpose. So it has different time limits. And, you know, there is this perception that the mischievous countries, the tax haven countries, the countries that made this happen are going to end up unjustly enriched as a result of having to claw back the aids. Whether that will happen or not remains to be seen.
Any other questions or comments? Well, without further ado, we'll have a cup of coffee, I think. I think we deserve it after that hard morning's work. Thank you very much, Ashley.